Okay, good afternoon. Welcome everybody on this nice hot sunny day. What more could you wish for doing other than joining us for a webinar on business structure and succession? Are you set up to support your next stage of growth? And hopefully that's the webinar that all of you are expecting. So my name's Esther Carter. I'm a partner at Moore Kingston Smith. Lots of people joining us today, lots of familiar names on the attendee list. But for those of you who don't know us quite so well, Moore Kingston Smith is a leading audit, tax and advisory firm. We work with businesses across a wide range of industries, as well as not-for-profit organisations and private clients. And we're also part of More Global, which is an international network with presence in over 100 different countries, so very well placed to help clients with their international journeys. And we've also got a specialist advisory and legal team within MKS, supporting clients on business structuring, tax and governance, and generally helping businesses to ensure that their frameworks remain effective as they evolve. So, I mean, coming on to today's theme, really, many businesses sort of begin with structures that work really well in the early stages, but as they grow, diversify, or bring in new people and capital, those same arrangements can start to create inefficiencies, complexities, and sometimes unintended risks. And often the challenge isn't immediately visible, so profits might sit in the wrong place, and tax efficiencies can build up over time, and decisions around ownership and incentives or exits can just become a bit more complicated than they really need to be. And what once felt simple can sort of start to limit your flexibility, slow down your growth, and create sort of barriers to investment. So today we're going to step back and we're going to explore what drives this shift, what organisations should reassess about their structure as they grow, and what practical, effective approaches look like to support long-term success, flexibility, and resilience. So I'm delighted to be joined by our experts, Vicky, Nicole, and Andrew Bloom. Vicky Nicole is a tax partner at Moore Kingston Smith and works with private businesses and entrepreneurs to support their long-term goals. She builds trusted relationships and advises across the full business life cycle, from growth and structuring to succession and exit. She's very much known for her collaborative and practical approach and specialises in owner-managed businesses and focuses on using tax to support, not drive, her clients' ambitions. Andrew Bloom is a partner and head of legal services at Moore SGD Law. He advises businesses right from startups to owner-managed businesses and international groups. And he specialises in corporate matters, including restructuring, M&A, joint ventures, and shareholder agreements. And he's got lots of expertise also in employee ownership. Trust me and Andrew have done quite a lot of those together over the years. And he's very much known for his commercial results-focused approach and combines a strong legal knowledge with practical and commercial advice as well. So before we kick off with the questions, this session is for you. So please do ask questions. Please pop them in the Q&A function. A lot easier to keep track of them there. And then I will try and weave those questions into the panel questions that I have. Today's session is being recorded, so please do share with any peers or colleagues who are not able to make it today. And finally, there will be a little feedback form at the end of the session. It'd be super helpful if you could fill that out, because that does help us to shape future sessions. So let's get started then. So I think, Vicky, coming to you first. I mean, I talked a lot about the reasons one needs to consider structure as one grows, but why does sort of the structure really matter more than people might think or care to pay attention to as the business evolves and they get really busy doing 50 million other things?
Thank you, Esther, and good afternoon, everybody. Structure matters because, like most things, being proactive rather than reactive gives you time to think about it, to ask the right questions about your business, both now and what you're anticipating to need or to happen in the future. It gives you time. It gives you time to think about it, to adopt that right path, to avoid any hidden costs, blockers, problems down the line. And businesses grow, they do change, they do evolve. They very rarely stay still, particularly in our client base of sort of fast growing SMEs, family businesses. The size, the people, the direction of travel does change most of the time, and rightly so. That is commercially driven. But that's fine, but still check in, have a revisit with your advisors to make sure you're not creating problems down the line, things that you weren't anticipating. And leaving it too late tends to make it more expensive. You run out of time. It could do something that is, you could do something that is irreparable, or certainly less straightforward than you were anticipating. Certainly from a tax point of view, what you often think might be easy and make sense doesn't. So when I speak to people who are starting out, setting up their business, there's a lot of time and attention on this kind of conversation. What does the structure look like? So just because you did that at the start for a business in its infancy, or certainly one growing up to say maybe £2 million turnover, if you're adding on more subsidiaries, if there are different divisions as it's evolving, when you get to say 10 million turnover, what looked right initially may no longer be the right thing for you.
Mm. Thanks, Vicky. So, Andrew, I guess from a sort of maybe focusing more on the legal perspective, what are the sort of the key problems and challenges that we come across? Have you got some sort of real life examples of what these might look like?
Yeah, absolutely. Hi everybody. So a lot of the issues we see aren't necessarily because anything's been done wrong. It's often because the
Mm.
business has grown and the structure simply hasn't kept pace. One common example is where different activities sit within the same company. You might have the trading business, valuable intellectual property, surplus cash, and maybe even investment property all held together. This can create unnecessary risks because if a claim arises against one part of the business, it potentially puts all of those assets at risk. Another issue we frequently see is where a business has developed a number of companies over time, where intercompany arrangements and charges between them don't really reflect how the business operates in practice. Often the paperwork hasn't kept up, which can create uncertainty and questions from investors, lenders, or buyers carrying out due diligence. A structure can also become a barrier to growth. For example, a lender might struggle to understand how money and assets move around a group, which can make financing more difficult. Similarly, we see situations where an investor is interested in one part of a business, but because of the way the group is structured, it's difficult for them to invest in that activity without becoming involved in everything else. Shareholder structures can create challenges as well. Over time, individuals may end up owning shares at the wrong level within a group, which might not matter day to day, but it can become a real issue when you're looking at succession planning, bringing up the next generation, rewarding management, or ultimately planning for an exit. One of the biggest areas of risk we see is around intellectual property. Businesses often create IP very early in their journey, whether that's software, branding, designs, or proprietary processes. The issue is that the ownership position isn't always as clear as people assume. Sometimes the IP was originally created by a founder or a contractor, but it hasn't been formally assigned to the company. It rarely causes problems in day-to-day trading, but it becomes a major point of scrutiny when investors or buyers come in. A key part of our role is helping clients identify and fix any gaps so that ownership is clear, enforceable, and properly documented before it becomes an issue in a transaction. The common theme, I think, running through all of these issues is that it's the structure that might work perfectly well when a business was smaller may not be right where the business is today, particularly if you're looking at growth, investment, succession, or an eventual sale.
Thanks, Andrew. And Vicky, I suppose coming onto the tax side, what sort of problems and challenges and examples of such might we see there?
So what I would say I see most on the tax side is what I refer to as the forgotten taxes. So your stamp duty, land tax, stamp duty, degrouping charges. A lot of these are sort of time sensitive things. So will have related to a particular restructure in the past or a certain event in the past. If not enough time has passed, or if indeed it happens once a buyer has been found, for example, it can restrict what tax planning options are available to you if not thought about in time. So essentially something that could have been tax neutral or certainly managed from a tax risk point of view, or when the values of things were lower, may no longer be possible. That is what becomes real and expensive in terms of when we're thinking about a transaction or an exit. Picking up on some of the points that Andrew had raised, intercompany interactions. If you do have a group, if you do have subsidiaries, particularly if there's some overseas ones in there, things that have arisen through lending of money or trade flows, those intercompany balances where they're not documented or they've not been thought about can lead to trapped tax losses, for example. Restrictions on group relief can lead to hidden transfer pricing issues if not thought about in the right way across each subsidiary. One of the other key things, again, touching upon what Andrew has mentioned, anything to do with employee equity reward and tax efficient or non-tax efficient share schemes, looking at that equity and who should hold that equity and how they hold it and where they hold it may have been right at one point in time, but as things evolve are no longer relevant. I mentioned overseas matters, overseas planning when we're looking at businesses who are expanding, growing, looking at a presence overseas, not thinking through the funding of that overseas venture or branch, as well as repatriation of profits can cause tax leakage if not thought about properly. And I do caveat the tax element shouldn't be your lead design principle in all of this, but certainly having a regard to what an HMRC view or maybe a future buyer view or their approach to tax risk is key to overlaying advice that you take at the time. And I suppose just to step in, we've covered legal and tax, just a couple of accounting points in terms of where we see problems. It's where things have developed and evolved, and perhaps your management accounts are not showing you the real information or the right information that you need for quick and effective decision making. You can end up with, again, not so much tax losses trap, but distributable reserves not being where they want to be. So the accounting side and how the accounting layers through that is also very important to review.
Yeah, absolutely. And when people think about structure, I think often people sort of what pops into their head is, oh, should I have a holding company or not? So in terms of holding companies, sort of when are they helpful to sort of have into the mix, and when might one not really need one?
So a holding company structure or putting a holding company in place is often people's first venture into being a group instead of a standalone entity. And I think, as Andrew mentioned earlier, a key thing there is asset protection or risk protection. Operating in a group structure, having that holding company on top allows you to have, say, different subsidiaries for your different divisions or your different trades. It allows you to segregate that risk. And so you can have things like property or cash or intellectual property, for example, either sat in a sort of sister subsidiary or at that holding company level. From a tax point of view, it's relatively easy or tax efficient to move those profits or property up into a holding company. Dividends, if we're looking at the UK, usually tax free up to that holding company. So it's a managing risk thing. It works for the tax side. If you're reinvesting profits as well, rather than taking that out at shareholder level, a holding company is a good way to get profits from one business up, pass it down into another, and you can then even tax efficiently sell one of the subsidiaries rather than all of them. But it's also very helpful to have if you have a creditor, if you have litigation going on with, say, one of the companies in the group, particularly if there's litigation going on in the US, we see quite often, or if a subsidiary becomes insolvent, for example, it can be very helpful if the company that's involved doesn't sit on any other assets that may have nothing to do with it otherwise, and they are protected and ring-fenced somewhere else.
Yeah, thanks, Vicky. And Andrew, what about from the legal perspective? What are the sorts of things we need to think about when we're considering having a holding company in the structure and whether we need one?
It's a really good question, because having a holding company is often seen as the default answer whenever people start reviewing their business structure. And certainly, as Vicky said, there are often very good reasons for having one. But we also don't assume that a holding company is automatically the right solution for every business. One thing we remind clients is that every additional company adds a layer of complexity. There's more legal entities to administer, more governance requirements, more documentation, and more moving parts for management to understand and keep on top of. We also see situations where the structure evolves over time and different investors, shareholders, or joint venture partners come in at different levels within the group. That can work perfectly well while the business is operating day to day, but it can create complications later on, particularly when you're looking at a sale, an investment round, or a succession event. For example, a buyer might be interested in acquiring what management sees as the business, but legally there might be multiple shareholder groups sitting at different levels of the structure. Unpicking that can become complicated, and sometimes more complicated than anyone ever thought. From a legal perspective, what matters most is that the structure reflects the commercial reality of the business and supports where the owners want the business to go in the future. We need to make sure that the structure serves the strategy, not the other way around.
So I think, thinking about, I guess, if there's more than one trade, if you've got some overseas entities, thinking about if you want to sort of reinvest profits or whether you want to extract them, if you've got some IP or other asset protection is needed, if you've got property within there, all of that sort of helps if you've got a group structure and a holding company to sort of protect those positions. And particularly, I think, like you said, Vicky, if you're looking at an exit of
Absolutely.
one or other parts of the business, that can really help as well. So I think there are lots of pros, lots of cons, but every situation is very unique to the particular company and what growth journey it's on and what its future plans are. So I guess, Andrew, sort of still staying on the legal side of things, can you tell us a little bit more about sort of the legal matters generally that you should sort of look out for when businesses are growing, and where you see businesses sort of perhaps struggle a little bit with things that possibly could have been preempted?
No, absolutely. So one of the interesting things about legal issues is that they often don't cause problems while the business is trading successfully, but we tend to see them surface when there's a trigger event. So an investment, a dispute, a succession exercise, or a sale process. And there's quite a few areas that come up quite often. The first is constitutional documents and governance, particularly the company's articles of association and any shareholders agreement. These documents set the rules for how the business is run, board structure, information rights, approval thresholds, and who can block what. Many businesses are still operating under documents that were adopted when the company was first formed and haven't been reviewed since. The business may have changed significantly. New shareholders might have come in, management responsibilities might have changed, but the legal documents haven't kept pace. Some key things to look at are whether reserved matters and veto rights slow down decision-making, if information rights match the way the business now reports performance, and whether the board composition still reflects how the company is actually run. The aim is to reduce friction before a fundraising, expansion, or exit. Another area is intellectual property, which I touched on earlier because it's one of the most common issues we see. Business owners often assume that because they paid for something, the company automatically owns it. Unfortunately, that's not always the case. We often see software, branding, designs, or other valuable assets that were originally developed by founders or consultants without the correct documentation in place. It can usually be fixed by agreement. It's much easier and cheaper to address proactively than during a due diligence exercise when a buyer or investor is asking difficult questions. A third area is the funding arrangements. Businesses are often focused on securing funding, quite understandably, but they don't always appreciate the longer-term implications of the documents they're signing. We see issues around investor rights, consent requirements, personal guarantees, security arrangements, and restrictions on future transactions. None of these are necessarily problematic, but it's important to understand how they might affect future plans, whether that's bringing in further investment, restructuring the group, or preparing for an exit. We try to help make fundraisings faster and cleaner by getting three things right. First, eligibility and structure. For SEIS and EIS investments, we coordinate advance assurance where it's needed, help keep the company's activities and share terms compliant, and align the share cap table so that future funding rounds aren't blocked. Also, documents and due diligence. We prepare and update the shareholders' agreements and articles, draft subscription share purchase documentation, help with the data room and disclosure pack, and make sure investor rights are calibrated for future rounds. Thirdly, and as a multidisciplinary firm, I think this is where we often add the most value, we liaise really closely with colleagues in our tax, accountancy, and corporate finance teams so that the whole process is joined up. And finally, I'd just like to mention international operations, because more and more businesses are operating across borders much earlier in their growth journey. A UK business might have overseas customers, contractors, subsidiaries, or intellectual property being developed in another jurisdiction. From a commercial perspective, that can all make sense. From a legal perspective, it can create additional complexity around ownership of assets, regulatory requirements, enforcement, tax considerations, and other issues. We've got great contacts throughout our more international network who can help with these issues. What we often find is that these types of issues has arisen for perfectly sensible commercial reasons, and the challenge is that no one's had a chance to step back and look at the bigger picture. So the legal exercise is really about identifying risks, making sure the legal framework supports what the business is trying to achieve, whether that's growth, attracting investment, succession planning, or ultimately delivering a smooth and valuable exit.
Can I just step in there? Sorry, with a very quick sort of plea or support. You mentioned SEIS and EIS, which is a tax efficient way to invest in some of these companies, these startups. Just to reiterate the point, if there's any restructuring going on, there's so much time and effort will be put in to make sure that those investments qualify in their original investment period with any restructuring. And if that's going to move to a different equity ownership, we need to look at that in advance of anything taking place to make sure that that very valuable tax relief, that qualification as an EIS or SEIS investment isn't lost. Joined up approach.
It's so easy to trip yourselves up there. I say to clients who've got EIS or SEIS, literally just don't do anything.
Don't do anything until you ask.
without talking to us first, because things will trip you up that you might not have expected to trip you up. Now, obviously, businesses are growing in turnover or geography. They're probably going to be bringing on more people, and no business can successfully grow without making sure it's looking after its employees and also really thinking about its sort of key leadership team. So I guess maybe coming to you, Vicky, what sort of things do businesses need to be considering on the sort of the people front?
Yep. Very good question. The people aspect can often be underestimated, but actually it is where structure has one of the most immediate and practical impacts. That's whether you get it right and when you get it wrong. So because that structure and everything around it, the way you report, the way the results are measured, driven, that directly affects how people engage with that business. So in terms of control, whether it's incentivizing them, accountability, a structure that supports that in the way you want it to do, supports that leadership development rather than blocking it is key. You want to make sure that your structure works for you and your people to ensure it is motivating them and that it is encouraging them to work together and not to compete where you might find there are conflicts. Similarly, if you get this wrong, a poor culture can be the first thing, a poor structure could be the first thing to undermine your culture in the business. If people don't feel that they have control or they don't feel that they have influence or impact over the right results or the right outcome, can cause problems, slow decision making. And what I often see in my client base with the SMEs is that the right people and the way they're involved, particularly if that includes equity reward, it's not always clear from the start. So I will regularly have a conversation that says, right, we're a year in, 2 years in, I promised Fred that he can have some shares, and you've got an amount, or the founder shareholder has an amount that they want to give. We can often do that tax efficiently if it's at the beginning of a journey. The values are lower, which is great, but actually trying to bear in mind that longer term view. Who else might need to be on board later? Who else might you need to attract in by offering equity reward? it's the sort of plea to avoid that accidental founder by giving away too much equity too soon. We do often just sit there and work through the numbers and say, if you give that percentage now, that's what that really looks like in 5 years' time when the company is worth X. Do you really mean that you want that one person to have that certain amount? So, like we said at the start, continual review of this is important so that it doesn't become problematic or costly further down the line when you want to bring more people in. That equity working alongside that share ownership working alongside your employees is very powerful if it is worked in the right way. It's equally very damaging. And where we often see the most conflict at a board level or where we're looking to prepare a business for exit, particularly as Andrew's mentioned, where the articles of association, where your shareholders agreement, where that legal documentation doesn't actually reflect the reality of how you're operating now, or the reality of how you intend people to get their value on exit, can make this very difficult if not thought about in advance. So I think in summary, with people, good structures support the right growth, the right progression. They do allow your leadership to take initiative, make the right decisions. Very important in a succession context, as mentioned, in terms of exit planning or who's next. But make sure you're taking the right advice with the people aside as well.
Yeah, definitely. And I think communication is a big part of that as well. If you've got sort of equity incentives in place, opportunities for people to kind of, realize some equity on an exit,
Yeah.
making sure they understand what they've got. I see a lot of businesses where people leave not having really understood what they potentially could have got further down the line.
Yeah.
And I suppose
A lot of times being promised something, but no one quite knows what it looks like
what
yet.
it is, how much it is, when it's going to happen, if it's ever going to happen.
Yeah.
Is it just jam tomorrow? Yeah, exactly. And Andrew, I suppose on a more basic level, just making sure you're reviewing your employment contracts, thinking about directors' contracts as well.
No, absolutely. And it's best to avoid just waiting until a transaction's about to happen to review those sorts of things. There's some key flags that we often see mean where it's a good time to look at these sorts of things before there's a transaction that's imminent. So here are a few flags that we often suggest to clients to have a review. One is if the business has maybe outgrown its original owner-manager structure, and future strategy looks a bit different from where it started. If founders or early shareholders are no longer actively involved in the business, if the business is rapidly evolving, entering new markets, launching new activities, if you've got surplus cash and you're investing it in property or other businesses rather than the core trade, where shareholders start to have different objectives or time horizons for investment and exit. As Vicky was saying, if you've got some key individuals who might have become too important to lose, and you're considering equity participation and succession planning. Also, if you're going to take on external debt and investment, you need to check that all your documents are right before you start down that path. Also, where you have valuable intellectual property or property assets being built up alongside the main trading assets in the same company. And perhaps most importantly, really just where you're starting to have conversations about succession, management buyouts, and a future sale. Even if those successions start informally, it's good to start looking at the structures that you've got in place. But a really common theme is that the structure should support where the business is going, not where it's been.
Absolutely. Any tax points to add to those flags, Vicky?
Yeah, I think really it's echoing what Andrew is saying about timing. Timing is the key here. As soon as the shareholders, the management team are looking at there being an event, most of the time by that we mean your exit planning, your succession events. And by that I mean not when you think, oh, we've had an offer for someone to buy us. I mean, when you can see it in the next few years, a couple of years at least lead time, fantastic to start having these conversations, to start putting things in place. The closer you leave things to think about to an exit event, for example, or a big event, the more, as I said earlier, you're shutting down potential other tax planning opportunities. So things like agreeing valuations for tax efficient share awards or moving things around the group can be problematic. I think even if it's not a restructure, it's what we work with our clients quite a lot on is having that almost like a trial run or a health check phase where we're saying, let's have a look at everything, not just from a tax point of view or a legal point of view, operationally, people wise. Let's look at it now and have that health check now and kick the tires now. We don't want to leave any open goals for a buyer or a buyer's advisors on a due diligence exercise, or when conversations on price have already started to happen. We don't want price chips, we don't want indemnities. We want to be making sure that our client's business looks like they think it should look like, well before anybody else is on the clock looking at it or involved in those discussions. Obviously, as you mentioned earlier, what good looks like for each business is very different, but building in that time and the conversations with the right advisors at the right time is essential.
Yeah, and trying to fix problems around the time of a sale when you're negotiating with buyers is a massive distraction, because all your energies will be on that deal and trying to keep the business going and new business coming in and servicing existing clients as well. And the last thing you want to be doing is firefighting with various issues. And from my experience, when deals are being done, a lot of the tax DD issues tend to come out around things like employment related securities, things to do with EMI and incentives. That's the sort of thing that tax DD will be all over.
Absolutely.
So important to get that right.
Absolutely. And I suppose what I often say to clients is, if the moment an exit event or a transaction or further investment comes into mind, every single thing that you do, you should have in your mind, someone else is going to look at this, somebody else is going to take a view on this, somebody else is going to see this written down, that I've followed the process, that HMRC knows. Always keep that in mind as a, what if someone was checking my homework?
Yes, and if they see any problems, they're likely to want warranties and disclosures and money put into escrow. So you'll pay for it. Pay for it somehow. So we've got a question come in for you, Andrew. So in what circumstances would you not, it's quite a specific question, in what circumstances would you not include a sunset clause from the perspective of an owner-managed business and shareholder agreement when the business is doing an MBO? If you were acting for both parties, what would your recommendation be?
I tend not to act for both parties.
Well, no, you would never do that.
You can get into it never makes sense to try and advise both parties, and there's restrictions against it. But like, every transaction's got its own got its own commercial merits. Whether or not people how you structure deals varies from deal to deal, and we see people structuring them differently. So it's hard to be prescriptive in terms of the type of deal and the commercial terms you put in. But we certainly look at what let the commercial realities of the business and the needs of the client drive things in terms of how we structure things.
Yeah. So very client specific, and very happy to have a chat. Perhaps we could, maybe end with some sort of war stories, some sort of practical examples that you've come across of things that have caused clients problems where they haven't thought ahead far enough. So maybe Andrew, if you've got a few good examples, or rather bad examples, I guess we're looking for, aren't we? Good examples of bad behaviour.
Yeah, there's two examples that I've had in the last couple of years where there's been some issues that could have been avoided. One, unsurprisingly, related to intellectual property. There was an important part of the company's IP that was created by someone who was never an employee, and there was no formal assignment in place to make the company the owner of that IP. And in the end, the client needed to offer a significant equity stake before the investment took place, in order to get the formal IP assignment. Otherwise, the investors would have walked away. In that case, the deal was delayed, but it still went ahead. But the founders were more diluted than they otherwise would have hoped. In another case, which was more serious actually, two business partners who'd started as friends with no shareholders agreement and only standard articles of association. One of the founders drifted away from active involvement in the business, but he retained some shares. when a buyer was found, the two founders couldn't reach agreement, and the buyer walked away. He pulled out of the deal. So it just shows that these things need to be got right. And if those particular people had reviewed their documents beforehand, that outcome might not have been the case.
And you know, I was sort of talking to Vicky about the sorts of things that come up on tax due diligence. Presumably, there are sort of things that come up on legal due diligence as well.
No,
That
it was
can be a
absolutely
distraction.
it was absolutely the case. In both cases, there were things that were pulled out of DD. The buyers' lawyers or the investors' lawyers spotted these issues, and you couldn't in those sorts of situations. There's no place to hide. It's too late to hide. You've got to see what you can do to scrabble around to solve it. In the IP case, we did, but it cost the client some equity. In the other hand, that they couldn't because the two owners of the business were frankly probably one of them was a bit intransigent and wouldn't flex in order to do the deal. So yeah, it was when you're acting for the buyer, the buyer's lawyers always want to kind of try and protect their client, but by spotting risks. Sometimes it's a negotiation tool. And the seller, you want to make sure that when you're opening up your data room for due diligence, you're not sitting there with your fingers crossed, worrying that they're going to find a problem, that that you've dotted your I's and crossed your T's. So that's what it's all about.
Yeah, better to try and preempt, even if you haven't planned ahead, at least try to preempt the problems before they get flushed out by the other side. And Vicky, if you've got a few war stories you want to share?
Yeah, I suppose it comes back to the points that we've already mentioned, but essentially, whatever it is, I think when you move to a transaction or an exit event or third-party funding coming in, it is the time where people are checking that what you think your reality is documented somewhere. So a lot of the times that I see issues, it is where that documentation, whether it's legal, whether it's tax, whether it's any other operational wise, is not actually operating as it should do. So things like we mentioned, people saying, that there will be equity reward for all senior management, but it's never, and they might have an idea of what that looks like, but it's not actually ever been put into paper. The nearer to a transaction, the less that you won't get the tax efficient share schemes, or if you do, they could be subject to challenge. What that's led to recently is similar to Andrew's. We sorted it out. We got the senior leadership team awarded with their bonuses to the numbers that they were expecting, but it's essentially come out of the seller's pocket. It's not been done tax efficiently. Similarly, a deal a couple of years ago, it was a global group where had been operating fantastically, commercially very successful. All of the different jurisdictions knew what their role was, how they interacted with other, how the trade flows were working. But when it comes to someone paying a price for that, if that's not documented properly, if that transfer pricing has not been agreed, signed off, and it becomes someone else's headache, that does make a real difference to the number on the sheet of paper when a deal is signed, unfortunately. So anything like that, anything to do with HMRC, making sure you've got your clearance time, that you're getting them on board on time for anything they need to stamp, sign off on. Doing it in good time, having things in writing is every war story I can think of comes down to things not being documented or implemented in the way that the business thought it was, whether that's bad advice, whether that's hope that makes logical sense. So why doesn't the taxman see it like it? Well, they don't. So I suppose essentially doing things properly and getting it documented.
Yeah, thanks, Vicky, and thanks, Andrew. I don't have any more questions. When somebody's asked, when selling a company, how many years back do buyers typically look at? Yeah, it's a good question, actually. Not that means you only need to start doing things correctly from a certain time frame.
So that depends on what you're looking for. The standard starting point, if there is a standard, if you like, people will say, I want to look at the current year and draft management accounts and tax position plus the last 2 to 3 years. But things like VAT can go back 5 years. Things like we say employment related securities, anything to do with share schemes or equity awards, that doesn't really have a time scale, because if that's wrong, the impact of what that means on a sale and the change of ownership can sometimes be so significant that it doesn't matter how far back that goes. Anyone who is a seller, any individual shareholder, or if it's employee shareholder who has equity, they will go back as far as they need to understand that history. But overall, 2 to 3 years as a standard starting point.
Well,
The caveats.
I'd echo what Vicky said. Certainly from the corporate perspective, if you're looking to verify and trace share ownership, you want to see a clear chain of succession. From day one when the company was formed, the previous shareholders validly transferred their shares. Anyone who received shares received them in a proper way. So you want to go back to day one in that respect. For commercial matters, if there's like assets or contracts that are no longer relevant and are long ago dead and not used, people will be a bit more commercial on those in terms of not taking a view. But certainly anything that's still relevant to that extent, people would want to be looking at.
Thank you. Right, there are no other questions. So I think the key message really is, if you're growing, whether that's scaling, developing new business services, developing succession management, growing internationally, bringing in funding, preparing for an exit, or any of the other things that I've missed out that we've talked about, the key is to make sure that your business's tax structure and its legal structure is evolving at the same pace as all those other things are going on. And our role really is to help bring all of that together. So with our our legal side, our tax side, our advisory side, our accounting side, and lots of other business services that we can provide, we can make sure that we're looking at all of that in a very holistic way. But the key is to make sure that you're coming and having those conversations early doors before all these things happen, rather than as they're happening or after they've happened. So I'm sure Vicky, Andrew, and myself would be more than happy to have any follow-up conversations with anyone who wants to explore anything that we've talked about today further. So I think that just leaves me to say thank you very much, Vicky. Thank you very much, Andrew. Thank you everyone for attending on this sunny day. Perhaps all feeling a little tired after the football last night. Hopefully not tired and hungover in the sun, because that's not a good combination. So
on a Monday.
On a Monday as well, yeah, not a good start to the week. So as I said, it's being recorded. Please do share it with any colleagues who were unable to make today. And if you could fill the feedback form in as well, that would be super helpful and much appreciated. So thank you very much. Enjoy the rest of your day.